We're going to turn now to the ABC News exclusive tonight after Donald Trump was fined nearly $355 million in his civil fraud case. Tonight, New York State's Attorney General Leticia James saying she's prepared to seize Donald Trump's assets, including his buildings, if he doesn't pay the money. ABC's Aaron Katersky one-on-one tonight with the Attorney General.
4 days after a judge ordered Donald Trump to pay $355 million for a decade of fraud, New York Attorney General Leticia James says she's prepared to do everything she can to make sure the former president pays his fine, including, she told us, seizing the buildings that bear his name.
If he does not have funds to pay off the judgment, then we will seek, judgment enforcement mechanisms in court, and we will ask the judge to seize his assets.
Trump was held liable for exaggerating his wealth and inflating the value of his real estate so banks would give him low-interest loans. Trump insisted the banks liked doing business with him.
They said no victim, no one got harmed, the banks got paid back, so no harm, no foul. Why is that not the case in your view?
So financial frauds are not victimless crimes. He engaged in this massive amount of fraud, and it wasn't just a simple mistake, a slight oversight. The variations were wildly exaggerated, and the extent of the fraud was staggering.
Now, to really understand why the events of late 2025 became terminal for the Trump Organization, we have to go back to the catalyst of this entire crisis. The story begins not in the chaos of a political rally or the drama of a criminal courtroom, but in the cold, hard arithmetic of a civil fraud judgment handed down by Judge Arthur Engoron in 2023. The judgment was staggering, a penalty totaling approximately $464 million, a figure arrived at after proving that property values had been wildly inflated to secure favorable loan and insurance rates. In the world of high-stakes real estate, debt is common, but a judgment of this magnitude, payable immediately or requiring a bond to pause collection, is a titan killer. You might be wondering, what exactly does the law require in a situation like this? Under New York law, the rules are unforgiving but clear. If a defendant wishes to appeal a judgment, a right Trump has exercised liberally throughout his career, they must post a bond. This bond acts as a guarantee, assuring the court that the plaintiff, in this case, the people of New York, will be paid if the appeal fails. The bond must cover the full judgment amount plus interest, swelling the requirement to nearly $500 million. For months, Trump's legal team engaged in a public relations campaign, insisting that negotiations with major bond companies were fruitful and that the bond was imminent. They painted a picture of a liquidity crisis that was merely a bureaucratic hurdle, not a systemic failure. However, as weeks turned into months, the truth became undeniable. The bond never materialized. The deadline passed, and the bluff was called. On December 20th, 2025, New York Attorney General Leticia James, having waited patiently through the statutory periods and the empty promises, initiated enforcement actions. This was not a warning shot. It was a direct strike at the heart of the organization's financial viability. So, what happened the moment that enforcement order was executed? The immediate aftermath was nothing short of the decimation of liquid assets and operating revenue. The aggressive nature of the seizure caught the Trump camp off guard. Attorney General James did not merely file paperwork. She executed seizure orders in Westchester County and simultaneously froze bank accounts connected to the organization. The scene described by witnesses, U.S. Marshals and New York State enforcement officers securing buildings and serving freeze orders, marked the transition from legal theory to physical reality. Let's look closer at why the Westchester seizures were so particularly damaging. They targeted operating businesses, not just static assets. The crown jewel of this seizure was the Trump National Golf Club Westchester. This property was not just a symbol of prestige. It was a functional, revenue-generating machine. Hosting tournaments and collecting dues from a wealthy membership base, the club provided a steady stream of cash flow that was vital for the day-to-day operations of the wider organization. When the state appointed a receiver to take control, the impact was instantaneous. Trump Organization operations were suspended, the management team was ousted, and the property was immediately prepped for auction, with real estate experts estimating its value between $75 million and $100 million. But the loss wasn't just the asset value, it was the loss of the income that asset produced. At the same time, we saw the state move on several residential investment properties in the county. These units, used primarily as income sources via rent, were also placed under receivership. The revenue streams were cut off overnight. In a business empire that relies heavily on cash flow to service debt and pay legal fees, losing these monthly injections of capital is akin to losing blood. But perhaps the most critical blow in those first few hours was the freezing of liquid capital. Investigators had identified between $75 million and $100 million in cash reserves sitting in various bank accounts. These funds, spread across different banks and entities, represented the war chest Trump needed to survive. Whether the accounts were named under the Trump Organization or obscure LLCs, the freeze orders hit them all. In a matter of hours, Trump's ability to pay for his mounting legal defenses, his bond premiums, and even his personal living expenses evaporated. He went from a position of purported liquidity to being cash poor in the most literal sense. But friends, the true checkmate of this saga lies in the failure of what we call the last resort strategy. Facing the seizure of his Westchester assets and the freezing of his cash, Trump attempted a maneuver that had saved him in decades past, refinancing his most valuable, unencumbered trophies. The plan was simple on paper. He would use the immense equity in Mar-a-Lago in Florida and Trump Tower in New York City as collateral to secure emergency loans. These properties, iconic and highly valued, were the final safety net. Reports indicated that negotiations were active, with certain private lenders expressing a willingness to look past the reputational risk in exchange for high-interest loans secured by such prime real estate. And this is where Attorney General James's strategic foresight absolutely devastated the defense. Anticipating this move, she did not limit her actions to the physical seizures in Westchester. She simultaneously filed enforcement notices in Florida and New York City. While these notices did not result in immediate physical seizure of the buildings, they achieved something arguably more effective. They created legal liens on the properties. Now, why does a lien matter so much in this context? The mechanism of a lien is a powerful deterrent in the world of finance. A lien signals to the world that the property is subject to a debt, in this case, a massive $464 million judgment. This transformed Mar-a-Lago and Trump Tower into what financial experts call toxic assets. When Trump's team approached lenders with these properties as collateral, the lenders saw the liens and immediately backed away. The logic of the lenders was purely mathematical. In the event of a default, a high probability given Trump's freezing assets, New York State, holding the primary judgment lien, would be paid first from the proceeds of any sale. A new lender would be second in line. Given the size of the New York judgment, there was a significant risk that after the state took its share, there would be nothing left for the lender. The result of this maneuver was catastrophic for Trump. The last resort failed because the collateral was effectively poisoned. All refinancing deals died immediately. The billions of dollars in paper wealth that Trump often boasted about became illiquid and inaccessible. He owned the buildings, but he couldn't use them. He was like a man dying of thirst while standing next to a frozen lake. The water was there, but he had no way to access it. This blockade on refinancing meant that there was no new money coming in to replace the cash that had been frozen or the revenue streams that had been seized. The financial engine had seized up completely. I want to pause here and ask for your perspective on this. Do you think the Attorney General was justified in blocking these refinancing options to ensure the judgment was paid? Or do you feel this strategy was an overreach of state power? Let me know your honest thoughts in the comments below. I really want to see what you think about this specific legal maneuver. As desperate reality set in, the battle shifted to the hidden corners of the empire, the complex web of shell companies. For decades, the Trump Organization had utilized a labyrinth of limited liability companies, LLCs, trusts, and shell entities. The purpose of this structure was twofold: tax minimization and asset protection. The theory was that if one entity was sued, the assets in another entity would be safe. It is a common strategy in real estate, but it relies on maintaining a strict separation between the owner and the entity. the corporate veil. But Attorney General James was steps ahead, having spent years mapping this maze. Her team had investigated these finances and mapped the flow of money between these entities. They argued in court that these companies were not independent businesses, but were merely alter egos of Donald Trump himself. They presented evidence that funds were moved arbitrarily to suit Trump's personal needs, disregarding corporate formalities. The court agreed. In a landmark ruling for the case, the judge permitted the creditors to pierce the corporate veil. This meant that the legal separation between Trump and his shell companies was dissolved. Assets held in trusts or obscure LLCs were treated as Trump's personal assets and were subject to the same freeze orders. And then things got even worse with the exposure of what legal experts call fraudulent conveyance. As the pressure had mounted in late 2025, investigators discovered attempts to move money and transfer property titles to new entities in an effort to hide them from the looming judgment. This is a serious legal violation. Fraudulent conveyance laws are designed specifically to prevent debtors from hiding assets to avoid paying what they owe. The discovery of these transfers backfired spectacularly. Instead of protecting the assets, it enraged the court. How did the judge respond to these hidden moves? Judge Engoron responded by issuing orders that froze not just the currently identified accounts, but any account that Trump had touched or transferred funds to in the previous 6 months. Furthermore, clawback provisions were initiated. This legal tool allows the court to reach back in time and reverse transfers that were made to defraud creditors. Money that Trump thought was safely hidden away in a new trust was pulled back into the frozen accounts. Beyond the financial loss, this exposed Trump to potential criminal liability for illegal asset hiding, adding yet another layer of legal peril to an already untenable situation. Now we need to pause and look at the human element here, specifically the psychological warfare that unfolded alongside the financial one. You see, throughout his career, Donald Trump has operated on a specific doctrine. If you are under attack, counterattack harder. If the facts are against you, destroy the credibility of the accuser. We saw this play out in real time on Truth Social in the hours following the seizure. The platform was flooded with dozens of posts, a stream of consciousness fueled by pure rage. He called Leticia James a racist, labeled her corrupt, and screamed about political persecution. He tried to rally his base, claiming that New York was stealing his property. But here is the crucial insight. This political noise, which had successfully intimidated Republican rivals and swayed voters for years, hit an absolute brick wall against the New York judicial system. Why did this strategy fail so miserably this time? Because a seizure order is immune to public opinion. A court judgment does not care about your polling numbers. In the court of public opinion, you can argue about witch hunts. But in a court of law, the only thing that matters is the ledger. Trump was fighting a legal war with political weapons, and the asymmetry of that conflict was fatal. Every time he posted an attack on the judge or the attorney general, he wasn't strengthening his defense. He was alienating the very judicial officers who held his fate in their hands. His lawyers filed emergency motions arguing that the seizures would cause irreparable harm to his business, but the judges rejected every single one. They essentially ruled that the harm was self-inflicted. He had months to post a bond. He failed. He had years to run a clean business. He failed. The harm he was experiencing was simply the consequence of his own actions, and no amount of caps lock ranting on social media could reverse a sheriff's execution order. And let's talk about what was happening inside those buildings, because the reality of receivership is something Trump had never truly faced. It wasn't just that the title on the deed was in jeopardy. A court-appointed receiver is not a passive figurehead. Imagine the scene. An outsider appointed by the state walks into the Trump Organization finance department. They have the legal authority to sit in the CFO's chair. They have the power to sign checks or refuse to sign them. They have the authority to fire loyalists who might try to funnel money out the back door. For a man who demands total loyalty and absolute control, this was the ultimate humiliation. The receiver immediately suspended operations that didn't comply with strict legal standards. The Trump way of doing business cutting corners, inflating values, moving cash between entities on a whim, was instantly replaced by rigid, state-monitored compliance. This was the moment the myth of the billionaire businessman collided with the reality of a state-controlled debtor. The operational paralysis was total. He couldn't order a payment to a fixer. He couldn't hide a loss in a shell company. The lights were turned on in every dark corner of the organization, and for the first time in his life, Trump was not the one holding the switch. This loss of control was arguably more devastating than the loss of the money itself because it stripped him of his agency. He was no longer the master of his universe. He was a tenant in a building he used to own, subject to the rules of the very state he claimed to despise. This sequence of failures triggered a domino effect that no one could stop. The first domino to fall in this final phase was the abandonment by his professional circle. Law firms, which act as the first line of defense, run on retainers. When the bank accounts were frozen and the refinancing failed, Trump could no longer pay his legal fees. High-powered law firms, no matter how loyal or politically aligned, are businesses. Multiple firms filed motions to withdraw from his cases, citing non-payment and a breakdown in the attorney-client relationship. And as you might expect, this abandonment spread like a contagion to his business partners. Vendors, contractors, and licensing partners moved to terminate contracts. The Trump brand, once a licensable asset, became a liability. Partners invoked moral turpitude clauses or simply exited agreements to avoid having their own payments seized by the state receiver. Then came the Leviathan, Deutsche Bank. As Trump's primary lender for decades, their relationship had been complicated but enduring. However, seeing the asset seizures and the liens, the bank declared the loans in default due to the deterioration of the borrower's financial condition. They accelerated the repayment demands, calling in approximately $2.5 billion in loans. This was money Trump did not have, compounding the bankruptcy of his empire. Inevitably, this financial toxicity poisoned his political power as well. Political donors, the lifeblood of any campaign, are strategic investors. They invest in candidates who can win and who can govern. Seeing Trump stripped of his assets, unable to pay his own lawyers, and facing the dissolution of his business, donors halted contributions. They viewed him as a financial liability, fearing that campaign donations might effectively be swallowed up by legal battles or that a candidate this compromised could not effectively campaign. Without resources, the political machinery ground to a halt. There was no money for rallies, for ads, or for the ground game. If we look at the timeline, the speed of this disintegration is breathtaking. On December 20th, the seizures began. By Christmas Eve, December 24th, lawyers were filing to withdraw. By January 2nd, the Supreme Court, seeing the writing on the wall and perhaps unwilling to intervene in a purely state-level enforcement of a valid judgment, denied petitions to block the release of further financial records. On January 3rd, the IRS, emboldened by the forensic accounting exposed in the civil case, announced audit findings demanding $1.2 billion in back taxes. Finally, on January 6th, the anniversary of the Capitol riot, the sequence culminated in a total collapse. New impeachment proceedings, war crimes charges moving forward without impediments, and the formal dissolution of the Trump Organization. Before we get to the final conclusion, if you are finding this deep dive into the financial mechanics of this case valuable and want to see more content like this, please take a moment to hit the like button and subscribe to the channel. Your support really helps us bring you these detailed breakdowns. So, where does this leave us? The events of late 2025 and early 2026 illustrate the mechanics of a fall that was absolute. It serves as a stark lesson on the nature of power. For Donald Trump, financial leverage was power. His entire career, and indeed his political persona, was built on the projection of wealth and the ability to access capital. He used debt as a weapon and a shield. But the asset seizures removed the foundation of this structure. Without the properties to act as collateral, there was no credit. Without credit, there was no liquidity. Without liquidity, there was no defense. Let's remember that the civil fraud judgment acted as the precursor that stripped him of his armor before the heavier blows landed. It rendered him defenseless against the criminal charges and tax audits that followed. Had he possessed the liquidity to post the bond, he might have bought another year of delay. Had he been able to refinance, he might have kept his lawyers paid. But the aggressive, calculated enforcement by the state of New York dismantled those options one by one. Finally, this saga demonstrates the terrifying efficacy of state-level enforcement. While much of the national conversation focused on federal cases and presidential immunity, it was a state attorney general, independent of federal control and pardons, who utilized standard collection laws to dismantle the asset protection schemes. It proved that no amount of complex corporate structuring can withstand a determined creditor armed with a court judgment and the will to enforce it. The last resort failed not because of a grand conspiracy, but because, in the end, the math simply didn't add up and the bills finally came due.